Hi, biggest brother. No, mommy, not you. Osan, hello, hello, hello. Anybody there? So sound online. Osan, it's only you and me that is here. Don't be afraid. Answer. Mr. Osas. Ah, wait, oh, this is actually being recorded. Oh my God. Can we stop this recording and start again so that what is there to say that one would not enter here, please?
If you can go Hello, Prof. Good evening, sir.
Good evening.
Good evening, yeah.
All right, sir. Thank you, sir. I've reached out to my colleagues, so they will join up shortly, sir, so that we can kickstart on time.
Okay.
Thank you, sir. Yes, sir.
Mm. All right. Once we hit 50 or so, we can start. If we start, others will learn about it and they can join.
Yes, sir. Yes, sir. Duly noted, sir.
Okay.
Thank you, sir.
Okay. Good evening again.
Yes, sir.
Now we
Evening,
are
sir.
yes, we are approaching 60, and I think we should start the class. I am confident that others will learn, will learn about it. They will join us so that at least we give ourselves an opportunity to cover some areas. I had informed the class captain to let everybody know they should join early. So we are almost 60. So it doesn't matter unless because the other time we were not able to cover as much as we have done. So now we have done the vehicles for just to recap. We have dealt with the issue relating to the vehicles for doing business. We've examined the sole proprietorship, partnership, and then of course, incorporation of companies, limited liability companies as well, and also the possibility to register a sole proprietorship under the Act, the company's legislation. We've also compared the relative advantages of these vehicles, which one is better than the other or more preferable. We look at the advantages of, they all have one form of advantages or disadvantages or other. And they are not too difficult to also remember because these are some of the things we do in our own individual lives. And we understand the essence of doing something alone or doing it with someone else. And there are problems here and there are disadvantages. Even when you register a company, it does not mean that all is well all of the time. There are challenges, but people do cope with those challenges. They seek to understand them and then and then endeavor to avoid those things. So today we are going to do two things. And that's why I feel sorry for those who are coming late. We are going to look at the regulations of these vehicles. Where I had sent to you quite ahead of time the Partnership Act, and then today we are going to look at that act as a contact point because every legislation that relates to or that regulates business relationship, of people or persons, they have peculiar provision types. We're going to understand those provision types. At the same time, we're going to use the Partnership Act in explicating this for purpose of examples, referring to them. We will do some exercises ourselves, and then in the course of doing so, we get to know better how partnership is organized or should be also organized and what the impact of the legislation you have been keeping with you for quite some time, what impact that legislation has on the partnership, business, or relationships. So that's what we are going to do this evening. Now, may I say again that when you are dealing with partnership, it's all about two or more people coming to do business for profit. It doesn't, yeah, I mean, it's as simple as that. We talked about the fact that it can be for a particular object, it can be for a specified period of time. It may also be for, an unspecified, unlimited period. All of this partnership could be brought to an end, depending on their circumstances and what the parties agree. But be that as it may, at the heart of partnership is negotiation. You have to, when you are dealing with someone else, not that is not you, and then much more than one person, you need to have agreement. You need to negotiate your relationship. You need to be very clear about what you are going to accept, what you will not accept, and document them. And all the partners signing up on it so that you reduce animosity, you reduce, malice, you reduce too much, arguments on matters that should have been straightened out. But then you will see the impact of doing that, or why it is even more relevant to do all these things I'm saying when you are examining the provisions. So, Partnership Act is a legislation that regulates, business relationships among parties. So, as I said, it it has, just as we can talk about the CAMA, Companies and Allied Matters Act, or the Sale of Goods Act, all of this legislation, they have certain key provision types. And those are the ones we want to start learning this evening. The first one of it is what you call the mandatory provision. Mandatory provision. They all have mandatory provision. The second is what you call enabling enabling provision. Enabling provision. enabling provision, right? Provision. And then the third one is what we call default provision. Now, under that enabling provision, we have alternative name. You can you can call that one as enabling provision or empowering provision. You will see why we say so, empowering provision, or even optional provision, optional. So those are the three major classifications. So now we take them one by one, and I will explain. I will identify how you can. I will discuss how you can identify it in a typical legislation and why they are in the act itself. Why they are in the act, we need to know. So that we can better understand why you need knowledge or some knowledge of this kind of provisions in your own personal life or business life to reduce, some anxiety, to create awareness, so that see, you can go see those who know better, who can properly guide you. Because the fact that you know there is something you don't know, quicken your spirit in finding out what is that you have to know so that your business can be run peacefully with your partners. Those are the important things, awareness. So a mandatory provision is a provision that mandates, that commands, it directs, it prescribes. When a provision directs you to do something, it's mandatory without any option to run away from it. When it prescribes the things you have to do, it's also mandatory because it's prescribing things or steps you must take. It is also mandatory. And when it prescribes, at this by prescription I mean telling you you cannot do one or two things, it's also mandatory. They are not begging you, they're telling you this is what you shouldn't do, or this is what you must do. Now, those are the meanings of mandatory provisions. So the next item is, why do we have it in any legislation? Now, a mandatory provision is like a leveler because it applies to all. It is usually done in recognition that in a relationship where people bargain, you see, when you are bargaining in life or in business, that's what we call bargaining power. Bargaining power. It is usually the case that all people that are in relationships who have to bargain or negotiate, they don't have the same bargaining power. They don't. There is always someone that has a better or a higher bargaining power than the other. So which means one is more powerful, the other one is weak. Okay. So, and when you are in that kind of relationship, it is possible for one to take advantage of the other. It is possible. If you go and join a company in which all you have is 10% and somebody is having 60%, you cannot, it is bound to happen that the person with 60% will cheat you based on his, you know, majority status. That is just the thing. Again, in life, people do marry, and what do? They negotiate. Now, depending on your status financially in life, when you negotiate, you see the hands of who is more powerful in this relationship than the other. Okay? So that also happens. Okay. So to be able to reduce, in order to reduce the extent to which a weak party in a relationship is taken advantage of, the law sometimes infuses, the legislature sometimes infuses mandatory provision into the act so that even though the person who have, a higher power would have done otherwise, but because the provision he has to deal with, it's mandatory. it is irrelevant that he has a better negotiating power. He is bound by what the law said it has to be. So that is the advantage sometimes of having them, or the reason for having them in a legislation. Furthermore, sometimes standardization in certain areas is important. So if the law wants to standardize, how parties should treat a particular issue in their relationship, it will make it mandatory. That once it is mandatory, nobody can come around and change it. So these are the reasons. You must bear this in mind. Mandatory provisions compels, it directs, it prescribes, it proscribes, and parties that are affected have no choice to change it. They must comply. Otherwise, they will face consequences. That is just simply as I can put it. So now, having so said, how do you recognize such provisions in the act to know that, okay, oh, this one, we have to comply with this? This is what the professor taught us. So once you are aware, you know it is mandatory, this is mandatory, you know how to deal with it because it's just compliance. That is the option you have. I'm going to share my own, and I want you to also open your own partnership act that has been with you for some time now. Let me see if I can share my own screen here. Okay, it appears I should be able to do so that we can also um, can share it. So now there are ways of locating or identifying this. Now, the traditional one is that when you are reading a section that talks about parties shall, particularly the word shall is directive, it compels. That is the implication of having the word shall. The other option is to have must. Parties must, but must is somehow inelegant. So it's hardly used in contemporary legislation, but shall is. And there are so many ways of having a provision dictated to us without having the power to change it, without even using shall or must. For instance, if you have a definition of a particular concept by a law, this enactment, a legislation, once it is defined, that definition is what the legislature wants you to understand it. It does not matter whether you have a better understanding. It is what they say. So you know, word means in this act means when once they say it, it means that definition is compulsory for everybody to take. You can't leave it. You must take it alone. Okay. Now, bear in mind that there are some definition too, which does not really use means, but says uh, director includes definition when you are defining director. Say this particular word include when it is including certain things, which means the one that is being stated that it includes must be part of the definition, notwithstanding that there will be other meaning that can join to it. That is how it wants you to understand it. In essence, the definition that includes is not exhaustive. It is not exhaustive. There may be other meaning to it, but the meaning given by that legislation must clearly be part of what you must deal with in applying that particular law. Okay, so bear that in mind. So a definition section also, as I said, and apart from even the definition section or the use of shall or must, sometimes it's just a statement. When a legislation issues a statement, you realize that that is it. It does not accommodate much more. He has said it. and we are all bound by it. The statement has been issued, and therefore we will take it. Now, let us now go into this act. I want us, I want us to go to let's say section one. I'm coming, just a minute. Now, when you look at section one of this provision, I'm going to show you some different types. Okay. Now, look at the definition of this provision. It says, partnership is the relationship which subsists between persons carrying on a business in common with a view of profit. This is a definition of partnership. So what this means is that this provision, because it's defining the concept of partnership under this law, is compulsory for anybody going into partnership. You must align your business, you know, in accordance with the terms and conditions and expectations of this section. So it simply means that for you to claim that you're in partnership, it must be you and somebody, either two or more, because it cannot be one person. You cannot say you are yourself and you are in partnership. That is not correct. Say between persons. So mean that person there is plural. That has to be more than one person. And what is person? Person can be natural person or artificial person. So you can be in partnership with a company because a company is a person. Or two companies can also actually come together to form partnership because those companies are also persons. So, and I want you to understand that much. Okay, so long as they are plural persons. Okay, and they must be carrying on a business together in common. Not that you have your own, I have my own. No, the same business, you are in it. You have told your colleague to let us go to Zamfara to go and prospect for gold and then form a business and then we will to make profit. That is the kind of it being in common. Not that, okay, when you get there, you do your own, I do my own. No, partnership has, the business has to be in common. And the third element is that it must be with a view of making profit. That is very important. If it is not for profit, then don't waste your time. It has to be for profit. That is only so it is only when you have more than one person that are doing business in common and that with the objective of making profit that you can say you can claim to be, you know, you can claim to be in partnership. So please bear this in mind. This definition is mandatory. Okay, it is mandatory. So we can go to section 4 again. We can go to, we rush through it because of our time. There's a lot to learn, really. The time is always very short. Now, number 4, when you look at for the meaning of firm or firming, um, persons who have entered into partnership with one another are, for the purpose of this act, called collectively a firm. And the name under which their business is carried on is called the firm name. So sometimes we talk about the firm, or your firm's name, and then or partnership. Okay, this is another way to describe a partnership, a firm. That is what this section 4.1 is telling us. Again, it's important that we understand this is an example, of a mandatory provision because it's defining to us what, how we should conceptualize firm. Okay, and that particular word is everywhere, we understand it. Now let's look at section 5 and every section of every partner is an agent. You can see that this one He's very silent about shall or must, but is telling you what is an agent of the firm and his other partners for the purpose of the business of the partnership. And the acts of every partner who does any act for carrying on in the usual way the business of the type that is carried on by the firm, of which is a member, bind the firm and his partners, unless the partner so acting has in fact no authority to act for the firm in the particular matter, and the person with whom he is dealing either knows that he has no authority or does not know or believe him to be a partner. Section 5 is talking to you about the relations of parties to person dealing with them. So it's saying that every partner is an agent of the firm and his other partner. So being an agent means that you can do, if two of us are in partnership running a firm, this law is telling us our status, that we are agents of one another. That is, I can act for the firm, you two can act for the firm, and whatever we do in the course of carrying on the usual business of our firm is binding on us or on our company or on our business. And it also binds the party that we are dealing with, except where that party or where the partner acting has no authority to act for the firm, and that the person with whom he's dealing, he knows that he has no such authority or does not even know whether he's a partner. So that is the situation in which those other person can be denied legitimacy on the business. But as between the partners, between or among themselves, each of them are each other's agent. So that is why it is important to always know and understand who you are dealing with or the power of the person you are dealing with. That when you say somebody has come in as a partner, whether you are the one that is actually sponsoring the business and it's all agreed that we are partners, we can do things for the company without recourse. If you want to be decent and methodical, we can agree. But if we don't talk about it, you do your own, I do my own. Well, I have gone there and have, you have, because the other party is bound, the firm is also bound, he has acted. And when he deals with third parties, so long as they have no way of suspecting that he's not, then whatever he does binds those people and your own firm and the other partner. So that is another way, of couching a mandatory provision. He's telling you what you must take and live with. Okay, what you must take and live with. It's very important that you know all of this as a partner. So that is again trying to unpack or open the box of partnership so you know how these things are done. Again, when you are signing a document, is it number 6 also says that any act or instrument relating to the business of the firm and done or executed in the firm name or in any other manner showing an intention to bind the firm by any person there to authorize that is a partner, whether a partner or not, is binding on the firm and all the partners. So when you are executing, so you can see the kind of power partners have. Okay, you will see later how you can deal with it. But right now, we are gradually knowing the kind of power the act confers in a mandatory manner that binds everybody on each partner, relation to one another and their business. So, but later on, you will see how the law also helps the partners to be able to solve these issues out. Okay, so long as they recognize that they still can adjust themselves, they have to still talk. Talking may affect some of these things we have been reading so far, because that is how they Act wants it. The Act is very flexible. Nothing is watertight. Nothing is sacrosanct because business, business dimension circumstances vary from from people to people or from pockets of partnership to another. So there may be a need for adjustment back and forth until they can find the equilibrium, that will give them efficient, documentation that regulates their relationship. Okay. So I have done to section 6. Okay. Now we quickly look at 9 and 10. Okay. Just to demonstrate the mandatory nature. That's what we are trying to use these sections I'm reading as examples of mandatory provision. Okay. Number 9 says, or section 9 says, every partner in the firm is liable jointly with the other partner. You can leave out this thing, you can put it in Nigeria. Severally also for all debts and obligations of the firm incurred while he is a partner and after his death, his estate is also severally liable in a due course of administration for such debts and obligations so far as they remain unsatisfied, but subject to prior payment of a separate debts. Now, this section 9 tells about the liability of partners. We've been saying partners can do this, partner can do that. You can sign, you can bind, you can do something for your partner and the business. The other party is bound by it. Now, number 9 is talking about liability. That for 3 people that are partners in a business, they are jointly liable. What it means is that everybody is indebted to the creditor. Because I told you, partnership is not separated from the business. I mean, the partnership and business is not separated from the owner, the partners, and the partners are also the business. So in terms of liability to third party, they are jointly liable. The implication of being jointly liable is that the creditor can sue one of them and collect all the debts without recourse to the other one. The one that is sued is the one that will go and get his colleagues to come and contribute. And that is the essence of severally. The several liability also means that they can all be sued together, or that if you pick on one of them because he appears to be the one that is mostly, financially stable, he can call the other people to come and also contribute to the indebtedness because it's a joint indebtedness. And you can see here, people take indebtedness to their graves because it's telling us that your administration or your estate, even in debt, will continue to be liable for your own indebtedness, and they have to pay. So if you leave something for your kith and kin, the creditors can also come to take his money because you don't have an estate until you have been able to pay off the debts of the man that has left. So that is also mandatory. That is how it is. But you will see later that that you can actually forgive one another if you all agree to do so. So the liability of the wrong. So number 10 is also within the same context. I will read it and then we move to the next section. Where by any wrongful act or omission of any partner acting in the ordinary course of business of the firm or with the authority of his co-partner, loss or injury is caused to any person not being a partner in the firm, or any penalty is incurred, the firm is liable, therefore, to the same extent as the partner so acting or omitting to act. What this one simply means, in another way, we call this one vicarious liability. But what it simply means is that if as a partner, since you are empowered to carry on business as agent of the other firm, your other partners of the firm, whatever you do wrongly or you omit to do, in the ordinary course of your business, the law says that, you know, the law says that the loss or the injury you have caused to any person who is not a partner, is binding on the firm. The firm is liable for that to the same extent as the partner so acting or omitting to act. So that simply means that a partner can bring problem onto the business if he's not careful. And so it is for everybody to be aware. And that is how the law wants that to be. Okay? So in this kind of situation, you realize that, is actually used to state the position of the law to the partners so that they can have a better understanding of their positions and what they could do about it. But right now, we are trying to extract what what we bind them, which they have to be able to be conscious of in dealing with themselves and in their negotiation or putting up the agreement. So it's not a joke that to say, from what we are seeing so far, you now realize that it's not just a joke to say, okay, you're a partner, but you must be interested in the agreement and the content of it. Because that is where you settle your matter before problem starts. And if you overlook it, then you may be in trouble. So now we now move to the second type, enabling provision. An enabling provision is the one, it is a provision that enables, that empowers. Okay? That is, it gives you options. They speculate what you will need. That is why you have all this bouquet of provisions. The lawmakers speculate what the partners may need because they recognize that negotiation sometimes is very difficult and sometimes it's expensive. So they they put some of from experiences, of people in business and all of that, they put together what may be acceptable and they put them in diverse form. One of those forms is the enabling provision. When the law enables you, you don't have to, take what they say you could take. They are just empowering you. The law is just empowering you. You may take it if you find value in it, but at least it gives you an idea of what could be done. You may get to the trust and objective of that section and then recast your own in your own personal relationship and business. That is what that means. So and how do you recognize an enabling provision? When you see a provision that is saying may, may is the word of enablement. You may, or it is a word of empowerment. May. So if I can check may here, and let us see how many of this may that we have. I know we can go to section 17. Section 17. Let's say may. Okay, let me go directly. There's no point to save time. Look at section 17. Now, look at section 17, subsection 1. It says, a person who is admitted as a partner into an existing firm does not thereby become liable to the creditors of the firm for anything done before he became a partner. Again, a person who is admitted as a partner into an existing firm does not thereby become liable to the creditors of the firm for anything done before he became a partner. So I want to ask you, class, that this section I just read, would you say how would you classify it? Does it enable or does it state a position of law that is mandatory from the ones we have been doing? What does that, how would you relate to subsection 1 I just read? Yes, and I want you people to please be talking. Don't keep quiet. Yesterday I had a class yesterday, fantastic. People were contributing, there, and I was quite impressed. So when you are making contribution, don't be afraid that you get it wrong. I don't expect you to get anything much right. But if you do, that is fantastic because you have experiences, you are out there. So, but the fact that you're able to say something encourages others to also want to say. And then it also gives you confidence. That is where, but keeping quiet all through doesn't really help. I know what I'm saying. So I just ask you a question. We have seen this particular type before about 3 or 4 instances or even more. How would you classify it? How would you classify, as a provision type? If you are not going to talk, my work is easy. I will run through it and we finish this class and we close. But then you ask
Hello, sir.
yourself, have you really helped yourself? So please talk. I'm begging you, otherwise you will not gain a single thing. You know what I'm saying? Yes, Lucky.
Yeah, good evening, sir.
Yep, go ahead.
Yeah, what I understand by that is before a partner joins a business,
No,
anything that
read
would
it
have,
again. Just
yeah,
just read it again
a
so that people
person,
can.
say a person who is admitted as a partner into an existing firm does not thereby become liable to the creditors of the firm for anything done before he became a partner.
Good. So what I
When I,
want you to just wait, what I want you to just say, I'm having read it from your own understanding.
yes, sir.
Does it does that provision give us a statement of law as it is, or it does something else?
It rather does an enabling one, because here the partner who is coming later may decide to be part of the liability that those people might have incurred before he joined, or says, no,
No,
I will not.
no. Well,
Good
if it's
evening,
okay,
sir.
let us take another person. Damilola, yes, go ahead.
So,
Yes, good evening, sir.
Good evening.
I think that is a mandatory provision,
Okay, why is that?
because it states that, let me read briefly. A person who is admitted as a partner into an existing firm does not thereby become liable to I can't say the rest. So basically, he actually mentioned that, though he actually
Okay,
didn't use the word
that's
shall,
the
right?
yeah,
What did you say?
yeah, yeah, that's the rest, please.
Okay. Does not. So because he didn't use the word shall, right? But then this particular word, which is does not, that he doesn't have to, like, is, to me, that the interpretation of that particular part means it is mandatory.
Okay, thank you. Mariam,
Thank you. Good evening, sir.
good evening.
Okay, thank you, sir. From what I can understand, the person who is admitted as a partner into an existing firm does not thereby become liable to the creditors of the firm for anything done before he became a partner. I think that statement is meant to protect the interests of that new partner in case a liability occurs right at that point he joined. So,
Okay,
because he was not there before such an incident occurred, he should not be liable to the debts incurred from such
so
an occurrence.
so as a result, you will classify as what?
And I would say it's an enabling one. It's supposed to make it easier.
Enabling,
Yes,
enabling.
sir. Yes, sir.
Okay, okay. So coming, Teresa.
Good evening, sir.
Good evening. Fast, 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 fast. There's a lot to do.
Okay, it is mandatory. It's a statement that is stated already, irrespective of what you think, whether you want to be part of it or not. The law has already stated it, so it is mandatory.
Okay, thank you. Is it Ajibola Abiodun?
Abolaji Emmanuel Abiodun, sir. Good
Okay,
evening,
sorry,
sir.
Abolaji guy. Sorry.
Good evening, sir.
Good evening.
Yes, sir. So I think in summary, considering the statement, it is mandatory.
Okay.
You know,
Okay.
considering like from, let me read this, the first line, a person who is admitted as a partner into an existing firm does not. That word
Yes.
does not is speaking to the present tense. It's not
Yes.
speaking to the past event. So considering the statement, it is mandatory, meaning that whatever event that might have occurred before the new partner joined is none of his business. He's only
Yeah.
concerned with as at when he joined the firm. Thank you, sir.
Okay. Thank you. Thank you. The last person, I think, yes, I think we've had enough contribution. I want to thank all of you that made contribution. I agree with those who say that subsection 1 is mandatory. It is. I told you at the start that some of the reasons why we have mandatory provisions in a business legislation is because the capacity, the negotiation, you know, I mean, the 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 level the level of negotiation, that the power that the partners have relation to one another varies. Some have a very higher power. Some have very low power, and in that kind of situation, they can take advantage of a new person that, okay, you want to join us. Look, we will take you in, but then whatever it is that we have done, you are also part of it too. We have some debts. You are not joining this our debt, and you are joining our glory. If you do not accept it, we are sorry. So that is how they will force you. How many times in our lives we have done things that we ordinarily wouldn't have done simply because we realize that the person we are dealing with have greater power than us, and we cannot say no to them. A lot of us have said yes to things that we ordinarily would have said no, but because we feel that if we do, there will be consequences. That is the kind of situation this 17.1 is addressing. A new person coming in is a rookie. He is a needy person. So, and it is likely that they will push a lot of things to the person, him or her, for him to take as a burden. But this section protects him or her, that person who is admitted as a partner into an existing firm, which means there is already a firm that has people as partners. He is coming to join them, and joining them meaning that he's joining them, with their excesses of money or excesses of liability. But this law is saying that that person does not thereby become liable to the creditor of the firm for anything done before he became a partner. The legislature has put him into a protective yard, that they cannot abuse him, because that is where abuse comes. They cannot force anything down on his throat. He's protected. So to that extent, it's mandatory. Okay. Now let us look at subsection 2 again, and I want you all to read it and also classify it for the class. A partner who retires from a firm does not thereby cease to be liable for partnership debts or obligations incurred before his retirement. How do you classify these two? So as we are doing it, most of you who are planning to be partners in a particular business, please follow these things. They help you. These provisions we are seeing and interpreting, they help you. They are the things that you will tell your lawyer, look, you learn a lot of stuff on partnership law, but I want you to, those enabling ones, those mandatory ones, the next one, bring them out, because I know they have implications. So help. So I have, is it Lucky or Teresa? There's okay. Ajibola is also there. So Abolaji is also there. So who is taking it quickly? Is it Abolaji now?
All right. Can I go ahead, sir?
Okay, yes, Lucky.
This is mandatory as well, sir. It's mandatory.
Okay, thank you.
Yes, sir.
Okay, yeah, I'm very sure. So it's very sharp question. So there's Teresa, quickly.
Yes, sir. It's equally mandatory.
Okay,
And I
any
believe
other
this is
question?
to protect all parties concerned. So you cannot run away from your debt.
Okay, so this, because this subsection 3 is saying that if you retire, you cannot run away from your indebtedness. You will still be liable for those debt and obligation. Because some people, when they're overwhelmed, what do? They run. They run. How many people have run away from relationships, whether marriage or business? Because there are looming problems, and they cannot just stop thinking about it. They want to distress themselves, and they say, I am done. I'm going. But this law says if you are a partner in a partnership organization, this law is telling you that if you retire from that firm, you don't cease to be liable for the partnership debt obligation that were incurred before you retire. So you are also informed ahead of time that you are bound by what you have caused with your colleagues. You can't share it and run away from it. So that is why it is mandatory. It's interesting. I want somebody to take subsection 3. Yes, I'm still seeing Ajibola's hand. I don't know whether you want to help with subsection 3. If yes, please go ahead. And if not, if there are other people, please read it. I've told you, how to identify with some keywords. So I think that should help. So, nothing. I'm listening. Our time is
Sir,
going.
this is
Yeah,
enabling. The
and
word
please go
subsection 3
ahead.
is enabling.
Okay,
Yeah, the key word there is may. It's an enabling word, like I said.
okay. It's enabling. Why? I mean, what is your marker?
May, the word may, stated that may, whenever the word may comes in, it's a room for
I
this
really,
or that.
yes, yes. I mean, I got what you said. I just want some words of explanation to your colleagues. If you can afford it, fine. If not, you just leave your answer that way. I can provide. But any other person who has a different approach to explaining this subsection 3, anybody? We are quite a lot now that are online. So I mean, we cannot just be relying on a few people, about 4 or 5 people, with a class this large. Okay. Yes. Anybody that still wants to talk, please go ahead.
Okay.
Um,
Hello, sir. Hello, sir.
yes, go ahead, man.
Okay. Okay. What I want to say is that since the way it is stated, it was not said to be compulsory that the partners can decide to discharge a retired partner of the liabilities, or they might not decide. He said a traveling partner may be discharged from any existing liabilities by an agreement to that effect. So what I said there is that it's not a compulsory one. It's just an enabling one. So you can decide to 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 release to discharge him of those such liabilities or otherwise.
Okay. 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 Thank you. Now, Abiodun, you want to add some voice? Okay. Now,
Hello, sir. Hello, sir.
yeah, go ahead. Go ahead.
Yes, sir. I think going by this statement, a retiring partner may be discharged from any existing liability, meaning that the decision to discharge the partner that want to retire is subject to their decision.
Yeah.
subject to a decision in the sense that as at when the partner wants to retire, it depends on whatever we agree, whether to discharge him or not. It's in two ways.
Okay. Okay. Thank you. Now, again, let me thank those who ventured to speak. Now, I just taught you that when you see the word may, it's enabling. It enables. And it will show. It says a retiring partner. We have seen two mandatory ones before now, but this one is using may. A retiring partner may be discharged from any existing liability by an agreement to that effect between himself and his other members of the firm as newly constituted and the creditors. Because if there is a liability, the liability is owed to somebody, and that somebody is called the creditors. And I'm sure you saw the word creditor in that particular section. Then the liability also is, the other members are also the one to carry it, plus the one retiring. But this section empowers his co-partners and the creditor to whom they are liable to pay to agree to forgive him. To forgive him. So having so empowered, he can then be discharged from his liability, so he can go on with his life into retirement without any burden related to the business. It's agreed. So what it therefore means is that those partners that are forgiving him will share his responsibility over their own. It is the law has empowered them. I told you this may, when used, empowers and enables, and it's also optional. They don't have to do so if they don't want to, but if they choose to, they may do it. And this is what this law is suggesting to them. Well, if you want to forgive your retiring partner, please, you can do it. That's the word may. It's your call. But when you are doing it, make sure that it is written down in an agreement so that tomorrow you don't deny that we didn't forgive him. And bring in the creditors too, who is the one really that you are going to pay his, what you are owing him to also have this hand. Because remember that a creditor can always reach any of the partners anytime. He can grab one person and sue him for everything. The other will contribute because it is a joint and several liability. But this one now empowers them, to forgive a retiring person. So that is how it is. And it also makes business sense in life. How many times have you forgiven someone who is owing you? It's the same thing here. It's just that this one is within the context of partnership. That's why I don't want you to always see this class as a technical class. It's a class that we are making to be as near as possible to what we experience in real life situation. Many of you have been forgiving people's debt, but you are seeing it here now. You are seeing law. Not that. And when you are forgiving, did anybody force you? Nobody is forcing you. So this legislation is, by this subsection, is just telling us what we have been doing in our life to forgive. Just as somebody who hurts you, who offends you, don't we forgive? The Bible says forgive and forget. And we do it as people of faith. It's the same thing. When you are forgiving somebody, their debts, you are doing it willingly. You are not forced. It's coming from your heart. So this is an enablement or enabling provision that I want you to bear in mind. Okay? So that is the explanation. And it's very interesting. That takes me to section 19. I want somebody to read section 19 quickly, please, and then tell us what it is. Oh, yeah, time is going. Time is going. This is already 7. Can you imagine? And there's a lot of things to do. Oh, yeah. Who is
The
there?
mutual right. Good evening, sir.
Yep. Go ahead.
The mutual rights and duties of partners, whether ascertained by agreement or defined by this act, may be varied by the consent of all the partners. And such consent may be either expressed or inferred from a course of dealing.
Okay. Now, how would you classify that provision?
Okay, so this is also, I can classify this as enabling because there's a may there discretional.
Okay. Any other person? Once you are willing to talk, just continue to talk. I'm not seeing the list of us so that I can call a particular person. So please, just any other person apart from the last speaker.
I think it's an enabling provision
Okay.
because the may is subject to the consent of all partners. It's an agreement between them, so it's an enabling provision, sir.
Okay. Now, thank you. I want you to reflect. We have been seeing some provisions that are mandatory, some that are enabling. Is that not right? We have been seeing some mandatory, some enabling. This one now, let us read it together again. I will read. It says the mutual rights and duties of partners. What we have been seeing so far are those rights and duties. We are still going to get to other duties. All the ones we have been reading so far relates to the relationship between the parties. Those rights and duties of partners, whether ascertained by agreement, that is, whether they are the rights that the partners have written for themselves in their partnership agreement, or those rights and duties that this act have stated for them. There are two sources: the agreement of partners and the stipulation of the act. The rights and duties of partners, they cover those things. This section is telling us that it does not matter whether what we read before, classification for before, is mandatory. Because we have seen some rights that are mandatory, some duties that are mandatory so far. This section is telling us now that whatever those rights and duties may be, stated by the parties or by this act, they may be varied. You can change it. You can replace it. That is what it's saying. You can replace it by the consent of all partners. The only condition here is that for you are enabled to change all these rights and replace it by the one you want, either to make it tough for your partner or to make it easy for your partner. You are empowered to do so. You are enabled to do so. But in doing so, all the partners must agree. They must consent. And that consent may be expressed, or we can infer it from your conduct. Everybody say, I agree, it's very important. And somebody say, just nodding. And when you are just nodding, those things are coming up and you are supporting it, there is no argument. Tomorrow you cannot say you didn't sign. If you have been going on with it and you understand what is happening, they will infer that you have consented. So this is an enabling provision, and this is one of the most important sections of partnership law. The fact that all rights and duties are negotiable. That is what it means, negotiable. So if you are finding yourself in a situation of partnership, nothing is sacrosanct in partnership law. You are seeing it from section 19. You can change it. You can vary it. you can replace it. You can modify it. Variation means that you can turn it around a little bit to the right, to the left, or to the center. It's possible. That is what it means. That is what it means. And it is very important that you understand the structure of partnership law. This is the heart of it. The one that subjects all rights and duties to variation, regardless of how it has been couched. The understanding we have before is cool, because if you don't know you can change it, those mandatory will still work for the partner as it is. The enabling, the empowering one or the enabling one will still work. But to know it this way is an added knowledge that affects virtually everything that is written here. Okay? Now, so we will stop there for now, and then we go on to the third classification, which we call default provision. Default provision. We are going to go to default provision now. Why it is in the legislation, how we may identify default provision. You see, let me tell you what is difficult in law is what we are doing now here. Because if you don't know these provision types, you cannot engage this any law, because all laws are written with those types of provisions. If you understand them, why they are in the act, and you can identify them when you see them, then the law becomes really very small to you. But because you are not trained in this thing, it becomes easy for us to give you service on this law, because we are taught, if we are properly taught in school, we can engage this, we know the implication. It's just like the doctor that is taught all the body, all the parts of the body, things that we are shouting and crying. When you get there, they are so calm. Please sit down. I will see you. Don't worry. All is well. And they are not in a hurry because they know they can deal with it. The same thing with lawyers who understand these things. They just, they will just take the law and then start asking you questions. What do you want? Because a lawyer must understand your concern, the law, and ask questions. But those answers you give will help in preparing you a workable agreement. He knows, he should know. So we are coming to the last part of it, default provision. Just give me 2 minutes. I'll be back, please. So I'm back now. So default provisions. Now, how do I explain it now? So I will start with what is common to every one of us. You know, all of the members, I mean, to start with, let me say, we a class captain. I am not too happy that those who are available here, they are just 80 something. It's not even up to 100. This is the least I've experienced since the beginning of the week. I don't know why it is like that, but you have to communicate better to your colleague. You know? So, default provision. Let us take it as the fact that all of us this class, we are given an iPhone or a Samsung telephone, all of us. We are handed one for the first time from the factory, and we open it. By the time we open those phones, what we are going to see to operate it is what they call the factory setting. And now I'm taking it to life, to technology, and I want you to bring back that knowledge to this law so that you can better understand it without too much stress. So you have a factory setting. That is the only way you can operate that phone. You first of all encounter, all of us, the factory setting. Okay. Now in law, in the equivalent of the factory setting in what we are doing is what we call underlying rule. Underlying rule. That is the that is the underlying rule for that phone. So which means every default provision also has an underlying rule. And I want you to follow me step by step so that you can take it fully and understand it as just one issue. So all default provisions must have an underlying rule. Okay. Now the factory setting that we have, apart from the manufacturers giving us their own setting, they also leave an empowerment. They enabled us. And what is that enablement that they give us? I want somebody to assist me. When you open a system with a manufacturer's setting, there is an empowerment or enablement in that equipment. What is that? I want somebody to raise up his or her hand and answer that for us. Because you are men of experience. What is it? And we have been using telephone. Oh yeah, somebody, please. Don't wait for
You
me to
can
call you. Once
change,
you know.
you can change set.
Huh? Say it. Once you start talking, don't ever hold back.
So can you hear me?
What do you?
You can
I can
change
hear you now.
settings.
They can change the
Change
settings.
settings. Yes.
Very good.
They
Very
also
good. Is there any other person?
modification.
Yes, modification is also changing because to modify, which means you are moving away from the settings. Is that not it? So
Customizing
somebody's
it.
very well. There's also a correct answer. They can change it. They can modify it. They can customize it. All of this language is what you can say you know these things, but you are shy to talk. And there are serious language you are using. That is right. They are all right. So the same thing with default provision. Every default provision also has a component of it that enables the user of that law to change it, to customize it. I'm using your words now. To change, to customize, and what's the third one?
Modify.
To modify. To modify. And then I will add one to it, to domesticate. To domesticate. Okay, I'll add that one for it so that you can take that away too. So therefore, when you have a default provision, we start like our telephone or our equipment. It has an underlying rule that comes with it. So in every default provision, there must be an underlying rule, and you must find that one out. Once you know the rule, you then go to the next level, the capacity to change that rule. to modify it, to vary it, to domesticate it. And why is that empowerment necessary? Why is that empowerment necessary? I will also go to the class. Maybe there will be one or two who can even provide an answer. You use your experience now to answer law questions, even without being taught. That is where we are, and you are making good of that. So why do you think that empowerment that the manufacturer puts in the equipment for the users to be able to modify it, why is it necessary? Yes, anybody?
So as to be able to use it to our satisfaction.
So as you can use it to your satisfaction, I will take that. But I still want some sharper answer. But at least
So that we can use it to suit our need.
Yeah.
so that you can use it to suit our needs. Okay, it's getting better.
All right.
For security, hello, sir. Can I?
Yes.
For security reasons, sir, and to
For
get a full ownership on the object.
Okay, to have ownership of it, so that now you can say this is your own setting, right? You are owning it now, your own setting. So which is domestication or a modification somebody was talking about. Now let me also help you now, and I'm happy for the words you have used, very close to it. You see, a default setting is a one size fit all. A one size fit all. In businesses, in relationships, a one size cannot fit everybody because we have different sizes. Those sizes we are talking about is the circumstances are different. They are telling you, stay on this channel for the rest of your life. You can't change it. You will be bored and run away. So the reason why enablement is there is to allow the users, in recognition that our needs are different. Look at this law. In your own partnership, if this law does not fit your situation, change it, domesticate it, modify it, vary it. That is the reason. Because they know that the underlying rule that has come with it is a one size fit all. People have different needs and they want to be able to satisfy that needs their own way. That is why they are empowered to change. That is why if you look at all our telephones today, they are all different from the factory setting because we have all moved on from it. We have changed it, except for those who don't care. And when you don't care, you are stuck with that one. So we have seen two levels. Every default provision has an underlying rule. Every default provision has an enablement component to allow the users to change it. Now, the last part of that is that if the users or any user does not change the underlying rule, then the user is stuck with that rule. I've told you that the law enables you to change the underlying rule to fit your own needs. But if either because of ignorance, your own ignorance or your lawyer's ignorance, you don't know what default provision means, you don't even know you can change it, and you keep quiet there, and then problem starts, and you are now in court. It is too late to change. Then the one you refuse to change becomes a mandatory provision for you. You are stuck with that one, and that is what the law will use to decide your case, even where it brings you dissatisfaction, agony, pain, disenchantment. You are stuck. So the three components: underlying rule, the power to change. Failure to change means that you are bound by that rule, whether or not it fits your situation or it does not fit your situation. So you can see the essence of knowledge, which if you don't have, you get into problem and then you are stuck. you are stuck. Let me give you an example where knowing how to change is important, or why you should change is important. Let us go to section 24. 24. Okay. Now, this section 24 tells us that the interests of partners in the partnership property and their rights and duty in relation to the partnership shall be determined by the following rules, but subject to any agreement expressed or implied. Now, what I have not taught you is that now that we understand the nitty-gritty of default provision and the components of those provisions and their uses and their significance, how do you identify such in an agreement? There are phrases that are used, except a contrary intention appears. They are empowering you. That phrases through which you use to determine that this is a default provision is the one that is empowering you, and the means through which you can make that change possible. You say, unless the parties otherwise agree. Unless the parties otherwise agree is a phrase of default provision to identify. Or unless a different intention appears. That intention that is different will come from the partners if it appears. Or unless the parties otherwise agree is also, or subject to the parties' agreement. Those are the phrases that is empowering the users of this law, default provision, to change it. Subject to any agreement. This rule will bind you. But if you do not have any other agreement, the rule will stay with you. You can't change it. And those who know, so you can find a situation whereby out of 10 partnerships, 9 of them understand default provision. They have looked at the underlying rule. They have moved on. They have changed it. The remaining one didn't know and stuck there. So they have similar problems. Those problems, those who know and have changed, have solved the problem themselves. The one that does not know and remain on the underlying rule will be stuck. So you can see that some partners will be smiling because they have done the needful, while some who don't know, who do not know why they should change these things to customize it, they will be in trouble. They will never be happy. And sometimes they kill one another because what they are going to get may not be the one that is fair to them. But because they cannot, they cannot change it anymore, it is too late. It's only the party that shouldn't benefit that will be benefiting. And at that point in time, they're ready to kill the person than to be cheated. But they will count it as being cheated by that person. But it's not. It's because they are ignorant. Okay? So that is how to identify a default provision. So when you look at section 24, it says the interests of partners in the partnership property and their rights and duties in relation to the partnership shall be determined. I'll come here by the following rules. These rules, there are 9 rules. We are going to finish it before we leave today. By these 9 rules, it will be determined unless or subject to any agreement expressed or implied. So except these rules now is telling us that they are subject to any agreement by the partners. But if there is no agreement by the partner because of ignorance, these rules will stay and apply to the partner. To the partner, whether they like it or not. That is in summary, a default provision. You can see it has components, it has reason why they must be there, and possibly or purposely, the legislature understand that they are just trying to help the parties. They know that their circumstances may be different from what they have given to them. Some, it will be okay. For many, it may not be okay. So we must empower them to change this rule in case they don't like it. It's only when it becomes technical, where parties don't know the meaning, the function of the type of the provision they are dealing with, and they didn't do anything to it, that they now suffer. But it would have been, if everybody had the same equal knowledge, which is positive, we will use it to modify our own lives, turn it around, and walk away from the rules that we don't like. If we like a rule, deliberately we will use it. If we don't, and for those who don't, they would have changed and moved on. So what I want us to do now, the remainder of our time, we are going to take these rules one by one. Already we have we have established that Section 24 is a default provision, and it has given us underlying rule, 9 of them. So you are going to pick one by one, read the rule, and ask and answer the question whether the parties or the partner should change this one, should domesticate this one, should modify this one, should customize these ones. One by one like that. After that, we close. So, number one, somebody should read this thing and answer. Anybody?
All the partners. Hello, can you hear me?
Loud and clear. Go ahead.
All right, sir. All the partners are entitled to share equally in the capital and profits of the business and must contribute equally towards the losses, whether of capital or otherwise sustained by the firm.
So do you think the partner should change this rule?
Yeah, I think this could be, depending on the partners, this could be domesticated. And that's
So why,
because...
sorry, just take it easy with your class, because they want to also enjoy you. So don't rush the answer so that we can get.
Okay, yeah. I said depending on the partners, this rule could be domesticated, and that's because of capacity. You know, 2 persons or more persons may not have the same capacity. We've seen instances where there are partnership of persons pooling capital. Some persons will bring 70% of the capital, the other person will bring 20%, the other person will bring 5%, the other person will bring 5%, and they will come together to form partners. So if this rule applies, it simply means such partnership would not hold. And even if such partnership holds, the profits will be shared equally among them, which is not fair to the partner contributing more.
Yeah. God bless you. God, I cannot say better than what you have done. You know, she's right exhaustively. I thought she was going to be stuck by giving when I asked why, but she got it. She got it. Maybe she's a partner somewhere in one partnership business. Now, and the reason she's given, I want all of us to understand that this rule, this underlying rule, this default setting, this factory setting is telling us that capital and profit of the business shall be shared equally. So are the losses. It's the capital and profit that they are sharing equally and the losses. They did not talk, this section doesn't talk about contribution. But in the usual normal partnership, contributions are never the same in most cases. Some will bring 50%, another will bring 30%, another will bring 20%. So 50, 30, 20. Now, if at the end of the year they make, say, 30 million naira as net profit, and the person that contributes 20% says, well, we thank God though, this is a bumper year for us. Please, managing partner, I have sent the details of my account. Can you please give me my own share, which is 1/3 of 30 million, that is 10 million, because since we are 3. But he contributed the least, and he wants equal sharing with those, even with those who contributed 30% and 50%. Is that fair? So if you do not change, so if you do not change this particular rule, it means that the rule will benefit somebody that has 20%, and it will punish somebody that have 50%. That is the reason why when you put yourself into how partnership really works, people contribute differently. And so for a rule telling them to share profit equally and losses equally, it will be unfair for instance, for the losses, somebody who doesn't really have much, who has contributed 20 instead of 50 or 30, you say he should also come and share losses because he may not have the capacity to do so. Again, that will punish it, but punish the person. But for profit, if it is equal, it will punish the person that contributed 50 and 30, and it will favor the person that contributes 20. And the sad part is that if the partners say no, Mr. John, why will you be asking for 1/3 of the profit when you contributed least? The man will say, please, I have said my own. If you do not answer me, my lawyer will get in touch with you. So which means he wants to go to court. And he is right. And he will win the case because the law says subject to any agreement expressed or implied between the parties. This is your rule. The question is that having been empowered to change this rule through your agreement, express or implied, did you change it? If the answer is no, my lord, I didn't change it, then you are bound by this rule. Whether it is unfair or inequitable, you are bound by it. So how would the two partners now feel towards Mr. John? They'll be looking for how to take him out. And this is where partners kill one another because of this money matter, because of their ignorance, because of their lawyers' ignorance to understand this default provision, and for failing to domesticate it. Because once you now know that you have a contributing percentages that are not equal, then you must change your profit sharing too, which say equally here. You change it that it will be in accordance with our contribution percentages. You change it. So thank you so much, my friend, the one that the lady that spoke. You spoke very well, and I'm happy that you got the hint of that thing because that tallies with experiences in many partnership out there. Okay, so someone else to take number 2. Let us move. We will not go if we don't finish this. Oh. Number 2, someone, another person, please. Somebody has to read number 2 now and take it. Time is running.
So the firm must indemnify every partner in respect of payment made and personal liabilities incurred by him. A, in the ordinary and proper conduct of the business of the firm, or B, in or about anything necessarily done for the preservation of the business or property of the firm.
Should the partners change this particular underlying rule?
Okay, so this looks as if it's standard and might really apply well. However, they still need to modify it a bit, I mean, to my understanding, because there's still some relativeness there. Because if a partner decides that he's doing something on behalf of the company, whereas he's doing it on his own behalf, maybe that thing backfires. He now tries to push it to the company. So it might be modified slightly, That's my thought, sir.
Okay, thank you. Any other person? Well, I think that the rule is fair on the face of it, because what it's actually saying is that whatever, the law already says that the partners are agents of one another. You can act in the business and stuff like that. So if in the course of helping the partnership, you have made payments which the partnership business must make on the behalf in the ordinary and proper conduct of the business of the firm, or in and about anything necessarily done for the preservation of the business or its property. You know, you have been proactive to protect your partnership business and property in the course of, or you have made any payment, in the proper conduct of the business. I think you are entitled to indemnity. It is proper that they indemnify. However, maybe if the partner doesn't want to leave it open and just open-ended, they can define certain things that before you spend so amount of money on behalf of the partnership, let us know and approve it. Don't come back and tell us you spend this thing and bring the receipt. People can forge receipt. Let us know and agree. So that to that extent also, I want to believe that, in fact, I want to say that your explanation and the dimension you brought to it is excellent. Thank you so much. Number 3 now, please. Rule number 3. Thank you. As I said, don't wait for me. You'll be reading it ahead if you're interested so that you can jump at it. And the 2 people that have done so far, they are doing well. I must tell you. They are doing. Number 3, yes. Who is taking it for us?
A partner.
Oh, yeah. Just say it. Take it and do it. If you get it wrong, we correct you. You can.
Okay. Good evening, sir. A partner making for the purpose of the partnership any actual payment or advance beyond the amount of capital which he has agreed to subscribe is entitled to interest at the rate of 5% per annum from the date of the payment or advance. I think this is fair on the face value, sir.
Okay, so the answer is that should the partners modify this rule or leave it?
They should leave it, sir.
They should leave it. Any other person
Yes.
that can, thank you, that can weigh in, please? She said
Yeah.
they should leave it.
Hello,
Hello,
sir.
sir.
Hello,
Yes,
sir.
yes.
Okay, so I think any adjustment that would be made could be made on the percent. If the partners feel like the percent is too much or too less, they could agree to just adjust the percent.
Okay, so
That's what I
therefore,
feel.
so in your own way, they should clarify that and modify it.
Yeah.
Yes, there's another gentleman who is also trying to talk on this issue. Yes.
Yes, sir. I was also going to talk on the percentage that it will all depend on the prevailing interest rate in the market, whether such a partner is satisfied with that 5%, and such can be negotiated. And on that note, the percentage could be adjusted.
Yes, thank you. That is precisely the sticking point. When they are talking about 5% per annum, and what is the going rate at the banks? 27, either 25 to 27%, and you are paying maybe additional 10 million to assist your own partnership over and above what you have already undertaken to contribute. It's like a loan, you know. And so if you are now stuck with 5%, they will be thanking you and laughing behind you. Aberi, you know, can you imagine? So the 5% is very, very inequitable, and it is in the interest of the partners and the party that is giving the money to be aware of these things and adjust the interest rate to track the prevailing market rate, for his own good. So that is the thing. That is also very good. So by the time we combine those 2 answers, you can now see we have come to the best option of it to make it more functional so that the parties and the partners can be happy with customization that they will bring into this default provision. Yes, number 4. Thank you, guys.
Number 4 says that a partner is not entitled before the ascertainment of profits to interest on the capital subscribed by him. Now, if I understand that, talks about their contribution to the business. And I think that as it is, this one is okay because you don't talk about profit when you don't know what the interest, you don't talk about sharing profit when you don't know if you are at a loss or you have made some gains from your business. So I think that is okay, sir. The way
So
it
the
is.
house, any interrogator or you accept that opinion. Is the opinion okay that we should leave it and that is ideal for the partnership to find what the profit is before you start thinking about interest? Because you must remove all of the expenditure, you must remove tax and all those things before you can talk about profit. So I think I also agree with him. So the answer is ideal. Thank you so much, sir. Now, number 5. Number 5, anybody? You see, I want to stay with you until we finish it. But if you refuse to finish it, I will not touch it. But don't blame you if you see it in your
Okay, I
exam.
want to take number 5, sir.
Okay, go ahead.
Okay, number 5 says every partner may take part in the management of the partnership business.
Yes.
Okay, I
Should they
think this
change
should
it?
be, yeah, it should be changed.
Why?
Yeah, so too many cooks spoil the broth. They should appoint a particular partner should be appointed as the main manager of the business. Everybody cannot bring up their own management skills. Everybody cannot manage the business at the same time. So a particular partner should be appointed as the main manager of the
Okay.
business.
Thank you.
Thank you,
Thank you.
sir.
Thank you. I think any other perspective, please?
Yeah, on the
Sir,
contrary,
Any
can
other?
you hear me?
I am looking at
Yes.
it that
Okay.
every
Well,
partner,
okay. One by one, please.
okay, the statement says that every partner may take part in the management of the partnership business. The
Yes.
word may does not suggest that they could all at the same time take part. But I think it's okay because the business may not stay at the state it was established. There could be growth to the business aspect. And when it begins to expand and every partner is competent and they are found worthy to handle one position or the other, I think it's okay the way it is. The may suggests
Oh,
that it's not a compulsory thing that they must all take part.
now, the word may is an empowerment. We said that may conveys empowerment, enablement. So which means if there are 3 partners and all of them want to manage, they can do it and you cannot stop them. So the issue is is whether or not, because if you leave it this way, they can all say, look, I want to also manage this thing. It's not you alone. And you are going to be leaking all the soup and be telling lies. Let us all be in this thing. Of course, that could be problematic, but then that is the reason why maybe you will have to article. Yes, there's a lady that was going to talk. I want to hear you. Yeah, there was somebody who was trying to say something before Frank. If you have changed your mind. Now,
Um,
Hello, sir.
let me, okay.
Yeah, so I wanted to add that even though this statement is an enablement or is an enabler, right? That suggests that anybody could do it. They could modify it in such a way that will stipulate the conditions for being able to manage the business, probably setting a board for appointing the person and some qualifications the person may have and things like that. So that it won't be
Yes,
too open-ended to be problematic or cause issues in the future.
okay. That's also a good, a good contribution for balance. I agree. And okay, yeah, there's another person struggling to also come up.
Hello,
This
sir.
is your time, quickly. Yes,
Sir, good
go
evening, sir.
go ahead, my dear. Yes, you're okay.
All right, sir. So, sir, my input here, I may want to disagree with my learned colleagues in this class.
Eh, who is your learning colleague?
Mr. Lucky. Okay, just kidding, sir. But from my own
Okay,
perspective,
go
I
ahead, go ahead.
think, in partnership is already labeled. We have the different kinds of partners. We have general, the active, sleeping, as the case may be. So, yes, the word may also, as opined by Mary Jane, that is an enabling component. But I think not every partner should take part in management because we have some who want to take the back seats and watch how things unfold by the brainiacs, by the ones who understand the nitty gritty of business management. That's what I think, sir.
Okay, okay, thank you. Thank you. Now, let me just summarize it. You see, you have to, the answer to me is it depends. It depends on the partnership. Partnerships have different dimensions to the partners. They have varieties. Some partnerships start small, okay? They grow big to a point that you get to a point when you need technical people. So if indeed you have partners that can handle the technical operations of this company, of this partnership, it could be managing the technical aspect. There could be issue of logistics. If the business has so grown, somebody can handle logistics that have capacity, and then the overall person that is putting everything together, like finances and all of those things can also come in. So what I will say is that as it is, it leaves it open-ended for partners to say they want to be part of management. It could be very chaotic. So sometimes you can now say if the partners is still very small, the partners is still very small, it is ideal to just allow a managing partner. But then so that it's not left alone unchecked, you can create a lot of strictures, a lot of conditions, so that it will be transparent and accountable. I think one person suggested something like that. That way, he's not left alone because it is ideal for a small partnership to have sleeping partner and managing partner. But those that are managing, they must have, the partnership must draw or customize this particular rule to ensure transparency and accountability by setting out what and what you happen. You must brief us, every three quarter, we will sit, we listen to you, you print the papers, you justify your expenditure and all of those things. And then if you cannot, they will let you know that they will remove you. All of those things are good. But when you deal with another set of partnership that are very complex and has a lot of branches, then you can agree that maybe you might need you might need the person talking, please block yourself. You might need to have more than one manager to handle, different aspects. Uh, okay. Now, so that is how I say it. There is somebody that is, we just had 3 minutes. This person talking just want us to leave this place unhappily, and it's very sad. We have been doing a whole lot of work here, and then you are bringing all this nonsense inside this place again. Because already I'm getting very angry. Okay.
Apologies, sir. I'll call her.
Now, number 7, please.
No, we've
Okay,
not taken
I'm
number
taking that.
6.
Number
Huh?
6, I'm taking.
Okay, yes, number 6.
Number
Go ahead.
6. It said no partner shall be entitled to remuneration for acting in the partnership business. I think on this point, there should be a kind of a modification of this clause, because in partnership, we still have a partner that are active in the business running, and we also have some dormant partner in the sense that they are not actively involved in the running of the business. So with this kind of clause, it will be a kind of disservice to the partnership business, in the sense that the person actually carrying day-to-day running of the business actually has to be motivated and incentivized in the business, in the operation of the business. So with this, in order to domesticate this, they need to modify it in the sense that
they should be partners that are actually actively involved in the running of the business should be in a way compensated for the effort they put into the business.
Okay, thank you. Thank you. I also agree with him. I don't know if others agree with disagree, because there's no point. I mean, if you are the one running up and down, time is money, So you are, and then you are not going to get other people's contributions or profits with your own. So, but for the one leading, and then spending your time and even some of your resources, you should be remuneration. But it's important also that if there's going to be remuneration, the modification should include the statement of what constitutes remuneration, so that everybody knows that, okay, this is how much is going to to collect, and stuff like that. Remuneration must be defined, must be identified, so that it leaves out any rancor. So modification is important for partners in this particular instance, number 6. But then there must be some other details that must be specified by the agreement that is modifying this number 6. Okay. So number 7, thank you, sir. I appreciate that. That's correct.
Hello, sir. I
Yes,
want to take
hello.
number 7, sir. Sorry, I
Go
was
ahead.
disturbing earlier. I didn't know about them. Okay. No person may be introduced as a partner without the consent of all existing partners. I
Okay.
think this rule should be maintained. I think it's fair enough.
Okay.
I
Why
think
do
it
you
should be
say so?
maintained.
Why do you
Yes,
say so?
sir.
You
Okay,
must
my
give
reason is
reason.
this. Okay, my reason is this, sir. If someone has to be a part of a partnership that's already been in existence, or a new partnership, other partners as well should be informed that such a person wants to come on board as a partner, and this is the amount he's willing to contribute and all of that thing. So it's very important that every other partner should be carried along, whatever is happening into the ownership structure of their business. So I think this rule is fair enough.
Okay. I guess everybody agree with that one. I
Yes,
agree
sir.
that.
I would like to add also that this kind of position brings about fairness, equity, and perfect agreement amongst the partners.
Yeah. So there should be modification. Sorry, I mean that we should retain this, so that we don't have a situation whereby few people will only bring somebody that they have really talked to behind. So, but by the law saying that all the partners must agree, it says that, I mean, it means that you must be able to convince your partners, your colleagues, to accept whoever you are bringing, and they must be able to ask, the relevant questions, even investigate to be sure that they are not bringing in strange fire that will destroy the partnership. That's why the consent of everybody for existing partners is very important. And it's not just majority now, it's everybody, not a majority matter, everybody. So I agree that it should be retained. Now, number 8, rule number 8. Yes, we're almost there. It's already 8. Okay. Number 8. Okay. Number 9. Number 9. Okay. We will stop at this point. And I want to really thank you. It has been wonderful to discuss all of this, and also to introduce, to be able to explain not only the provision, in the law, but also to apply it to partnership business. And now we know, we have a clear idea of how these things work, how we identify these provision types, what we are going to use it for, and stuff like that. So on that note, I want to wish you a very wonderful night, and have a very wonderful weekend as well. Good night.
Thank you, Prof. Good night, sir, and happy weekend.
Good night, bro. Happy
Nice.
weekend,
Good night,
sir.
bro. Thank you, sir, for the teaching. Thank you, sir.
Yeah.
Thank you, sir.
Good night. Thank you.
Thank you, sir.
Thank
Sir.
you. Good night, everybody.
Good night, sir.
Yep.
Good night, sir.
Good night, sir.
Good night, sir.
Good night, sir.